second. Let me think. What code section? Hold on a second. And they get their code and they start going through it, or you give them the case. You've already photocopied the opinion. They're reading the highlighted portion because you highlighted their copy, right? You highlighted the portion of the copy. So they're reading it again. I think you're right, counsel. Let me correct my mistake. Objection successful. Objection successful. Okay. So here we go. In re EA. Here it comes. Big case. And look at it now. I mean, it's so, it's not very threatening. In re EA. Right now, when you print it off of Lexis, it's got blue in it. And like I said, it's not a very long case. And if you've read it, you get it. Now, I got to tell you that when I was introduced to In re EA, it didn't look anything like this at all. This is how I got introduced to In re EA. Okay, so In re EA came to me looking like this. And why did In re EA come to me looking like this? Go ahead, Ms. Fern.
Because this is the best learning lesson for all of you.
Okay, so, for a couple of years, I have made a beeline to the writ attorneys because I knew that they were the ones that had the finger on the pulse of their cases. And so over the years, when I was in a trial court, I'd ask the writ attorneys to send me the cases. When they come off hot off the presses, send them to me. And they did. They obliged, and they would bring them to me. And oftentimes they'd be on my chair like this. I'd come into the office, ooh, and I'd see it, and it'd say things like, yes, great read, take another look. And of course, I'm looking at it, trying to see what's really exciting about it, or, sad for parents. This time, it comes in like this, and I'm thinking to myself, ouch, well, who got hurt? Okay, so then I took another look at it, and I said to myself, well, it says affirm, so, whatever it was that the person who argued and sent it up to the Court of Appeal argued, they lost. I'm assuming that's what that means, the ouch part of it. And then I saw this part, not to be published in the official reports. So it's just something for me. It's something for me to look at. Okay, so then about a week later, not to be published in the official reports. Eventually, the affirm part just left my head. I didn't even worry about it. Okay, and then not to be published in the official reports. So, I didn't think anything of it. And then a week later, or maybe two, I hear that it's now the hot topic at the Wednesday weekly mahjong game with the judges over there where Sherry Sobel and Jackie Lewis are getting together. They used to be in courtrooms way back when. They're not there anymore. And I'm like, what are they talking about this case? It's not even published. All right. So eventually, it came to my attention. That's me brushing it off. It came to my attention that it was more than just published, but in fact, it was a published opinion, and a published opinion was talking about me. Okay? It got so real at that moment that I had done something on the record that not only made it to the attention of Division 8, but made it to their attention in the worst way possible, and then published all across California for all to read. Okay, so here's the mistake. So let's go over it. Your Honor, this is not how I delivered it, I'm sure. This was 5 years ago, okay? Oh, now it's 8. All right. Your Honor, the father has heard the orders of the court. He is objecting to the suitable placement order of the child. He's objecting to the court order for parenting class, drug testing, individual counseling, and domestic violence counseling, as well as psychoevaluation, as it's unclear as to whether or not those services are being offered in the place of incarceration. He's also objecting to the court's order that has monitored visits only when released from his place of incarceration. Okay, that's the objection. Let me ask you guys. You guys play judge for a moment. What am I objecting to? Does anybody know what it is I'm objecting to? Any code section come to mind? or any language in the code that comes to mind? What was I even trying to do? Now you get from this part, he's incarcerated, okay? So this judge has just made dispositional orders, and I'm objecting to everything. So what I'm trying to say, but absolutely did not connect with the bench officer, was that there was a reasonable services issue. And somewhere in 361.5B, there's some language about when you're incarcerated and whether or not the programs are available, and the social worker needs to go and research to make sure that was what I was trying to say. But I did not say a single solitary thing to the judge. And in fact, I was just saying to myself, he should know. He's the judge. 361.5B, whatever. You know, the portion of it that talks about incarcerated parents. That's what I'm objecting to. And of course, the Court of Appeal got on that and said, yeah, had counsel gone on to say why it was an error, how to correct the error, then maybe he would have said more than just, thank you, because that's exactly what he said. And I remember it. He goes, thank you. And I said, well, you know, aren't you going to change it in my head? Aren't you going to change the order? No, he said thank you, and that's it. Okay, so this is what you do not do. You start with the objection, you say why it's an error, and you ask for what you want the court to do. Don't stop short at just the objection. Don't make the assumption that he knows what code section you're talking about. Don't make the assumption that just because you rose and said the objection, that he's going to reconsider. Like the case said, you have to get into a back and forth with the court. You have to have a back and forth, a discussion where he or she is actually reconsidering the decision that they made, and you are persuasive enough to get them to change their order. All right, moving on. Continuances. All right, so of course I'm trying to make sure that we don't have this feeling under the pressure of IAC, and that we can think about mistakes in a way that is survivable. So I put in certain ways to sort of dramatize what we're doing on the record. I am by no means trivializing what we're doing. I'm just trying to bring moments of levity. So here we go, continue.
First, Mr. Reed, I see where your client...
Your Honor, I would like a continuance.
This case has already been delayed several times, Mr. Reed.
I realize that, Your Honor, but I would really like a continuance.
I'll have to hear good cause, counsel. What's the problem?
I can't lie!
Commendable, Mr. Reed, but I'm still waiting to hear good cause, whether you have one or not.
No.
Motion for continuance denied.
All right. So I hope you guys don't think that I think that that's what you guys are doing. You guys are doing that, right? Okay. So continuances. So I see this a lot. So you should immediately be plugging in. It's Welfare Institutions Code Section 352. Now there's subsections, but immediately, if you're hearing someone say continuance, which I know you guys hear a lot, even before you go on the record, walking around, counsel over here, everybody's putting their court appearance sheets. What you gonna do on number 5? Counsel, I'm gonna do a calendar call. Number 1, that's a continuance. Every single solitary time you hear anybody utter the word continuance, you should immediately be thinking 352. And it's not the same 352 that you guys are shouting out when there's a witness on the stand and they're saying stuff and you go, objection, 352. No, that's evidence code. This is Welfare Institutions Code Section 352. And I gotta tell you, it's not the easiest read, but it's there, and it's always been. And we never use it. We sometimes use it, but we don't use it enough. We just kind of assume we're gonna get the continuance. We kind of assume we're just gonna get that next case, that next court date, and the case is just gonna move right along. But you gotta stop, and you gotta think, should we be continuing this case? How should we continue this case? What happens if we continue this case? Okay, so that's the procedural posture. You got to think, where am I at in the case? Is this the jurist? Am I already here at the 6-month date? Where am I at? And why is that important? Because the second most important thing when you're thinking about or someone's entertaining the court for a continuance, you got to do the math. You got to do some math. You got to think, okay, hold on a second. The detention came in. It came in January 3rd, 2018. Okay, that means 60 days from, you guys know where I'm getting that 60 days date, right? Okay, 60 days, that's going to be February, March. You got to do the math. And then assuming that you guys are beyond the 60-day already, you got to be thinking about that 6-month date. Okay, January, February, March, April. You have to start doing the math. And sometimes people jot it down on the detention, right? They just put it in, like, I don't know, on the court appearance sheet. They do the math. A lot of attorneys that I started with did it, and every single time I got that attorney's file, I see it on the front, and I'd be like, what is he doing the math? Doing the math is essential, and I never see enough records where someone is actually doing the math. They're not doing it on the record, but they have the date already figured out. The 60th date is this, so we shouldn't go forward past this. The 6-month date is here. We shouldn't go back. Or, Your Honor, the reason that we're going forward is, and that of course goes into, I'm starting to cite the 352. Now, the reason why I'm not teaching 352 is because I do want you guys to go to the code. I want you to read 352. Just drill it in there so that it just becomes rote. But at some point in time, you're going to be starting to bring up all the extra parts of 352 so that the court hits the brakes and doesn't necessarily continue the case or continues the case for a reasonable time. Moving on. Okay, submissions. Here we go to submission.
Is there any chance of settlement in this case?
I don't think so, Your Honor. My client has already offered Mrs. Cole $2.4 million, and Mr. Reed has made it abundantly clear he has no desire.
Settle! Settle!
I want to settle, Mr. Reed. You convinced me yesterday. I'm the victim here. I'm starved for affection. I'm driven into the arms of another man. Yeah, whatever. With the story you came up with, I don't think we can lose. I won.
Mrs. Cole, don't understand. Mr. Reed, do we have a settlement?
No!
Okay, so the thing about this particular dramatization is that in settling your case, you are doing some sort of submission on something, okay? You are not going forward on the hearing. You're not making any requests that are different, maybe, from the recommendation. You're not putting any evidence in, maybe, that's different from what's already been filed from DCFS and their reports. Okay, so something about your settlement involves some sort of submission. Now, one of the things in particular that I want to just point out, so Jeff Carey's character, the reason why he does not want to go forward is that he's not prepared. And I will speak for myself when I say that I have felt unprepared at times, where I have so much going on, and I know that this case is on for a contest, and I kind of remember what I'm going to say, but I'm pretty overwhelmed. I've got a lot going on, and so perhaps I may turn to my client and say, is there a chance that you want to just submit on the recommendation or something like that? When you're submitting, you also need to stop and think. What exactly are you submitting on or submitting to? And are you being clear about that? Not necessarily, well, definitely with your client, but as it relates to what the trial court understands what you're doing, and then assuming that the ruling is not favorable, what the appellate court understands that your submission is about. Okay, so when you're submitting on the report, that I think should trigger for you guys. Do you guys, when you do your waiver of rights, okay, somewhere, you're doing it, you're scribbling, you're doing it fast, the court wants to call the case, you get to the part where it talks about admission/submission. I wish to, and then it says A, admit the allegations of the petition. B, submit the petition on the basis of the social worker or probation officer's report and other documents, if any. And then C, plead no contest. Okay, when you're checking box B, you are submitting on the report. Now, I almost think that some of you guys are thinking about, well, my bench officer, whenever I check the box, he won't let me check the box. He only wants a no contest plea. Or when I do check the box and turn in my waiver of rights, the whole thing is done, including, the counts. The counts are already assumed to be found true. Let me just slow down. This document is simply just as to the evidence. The actual rulings and the findings that the judge makes as to the allegations, those are still up for grabs, but I digress. Let me just go back to here. So by submitting on a particular report or record, the parent agrees to the court's consideration of such information as the only evidence in the matter. The parent does not waive, for appellate purposes, his or her right to challenge the propriety of the court's order. And that's from In re Richard K. So just so that you know, the court still has to have enough evidence to find those allegations true. So maybe you guys want to mess around a little bit with the waiver of rights and perhaps maybe submit it and then be heard on the allegations. I don't know. That's just something to think about. I know that's not how we generally do it in the courthouse, but you can, in fact, send it up to the Court of Appeal, even though your client has done one of these. If there is insufficient evidence, there is insufficient evidence, and the court will still look at it. Okay, recommendations. Okay, so this is completely different. When you are doing a submission on the recommendation, by doing so without introducing any evidence or offering any argument, the party waives the right to contest the juvenile court's disposition or whatever is on tap, whatever is being contested, right? So here's where you got to think it through. So how many times have we gone into court, the judge is going through all of the matters on the calendar, and basically, we're going to do number 8. I'm submitting. We're going to do number 10. Hold on. Second call. We're going to do number 11. Oh, I'm going to submit on that. You're just kind of saying submit, not necessarily being really specific about what exactly you're doing the submission on. And especially by the time he or she calls the case, you want to be super clear, because there will be times where there'll be a miscommunication. And the court may then assume that you're submitting on the recommendation, and that's where you want to object or do something to call the court's attention. No, I'm not doing that. I misunderstood, or we have a misunderstanding. I'm submitting on the reports. I want to be heard as to the order. So you don't want to go so fast to get these cases off the calendar that you aren't clear as to your bench officer and certainly on the record as to what you are submitting to. Oh, that's me making the wrong. Okay, closing arguments. So this portion of what you're doing when you're presenting on the record, it does not have the effect that the other portions of being on the record has on appellate review, because I think you've already heard from someone, a supervisor, a colleague, your judge. Closing argument is not evidence. It's just your opportunity to persuade the trial court to rule in your client's favor. I've seen records where the closing argument seems to also be an opportunity for the trial attorney to bring in more evidence, that's not the time to have done that. The time to have done that would have been at the time when the evidence is being admitted, is being marked. That is your time. Once the court has closed evidence and is asking for closing argument, you can't start talking about what the mom, was going to say, or by the way, the grandma who's in back of the courtroom, she also believes, or the kid wants to go home, or I have this letter here. It says that she's five sessions short of a certificate of completion. If it is not marked and admitted, it is not part of the record. It cannot be part of your closing argument. The other thing about the closing argument is that you want to summarize the case and you want to tell a story. So before we go any further, let me just kind of show you how I like to think about closing arguments in my head.
Power.
Roll it out.
One slip, and you're gone. Bammy.
Okay, so that's how I know I feel when I'm about to do a closing argument. I want to make sure that I've got all the facts in my head, that they're all synthesized and summarized. I want to make sure that I'm going to address the legal authority that governs the court's decision. I want to make sure that I address not only the great facts that are either in the social worker's reports, but perhaps came through in evidence when I put a witness on the stand. And then here's the other thing that I want to encourage you guys to do when you're on the record. Talk about the bad facts. Because I don't know how many times, eventually, when the court does rule, the court starts to talk about all of those bad facts. And that could have been an opportunity for you to marshal those facts in a way so that the court doesn't feel like they got it. That's the one thing you didn't mention, and it's the one thing that's going to make their decision. If you get those bad facts first and start distinguishing them or start pointing other parts of the record out as to why those bad facts shouldn't be the reason why the court ruled against your client, then you have an opportunity to really have a dog in the fight. The other thing about closing arguments that I often see is when you're citing a case. Sometimes I see things like, Your Honor, I'm asking for the court to make a no reasonable service finding under Elizabeth R. And had the court or had the social worker called the client or had the social worker visited the client in the jail, then this would have been different. So with the reasonable services argument, first of all, just citing to the name of the case isn't enough. Let's assume that the court just does not know Elizabeth R. You have to be the one that knows it backwards and forwards. And certainly the parts of the case that actually have anything to do with your case. And then, of course, when you say, well, had the social worker called the client or had the social worker visited the client in jail, you want to continue on and say what it was that would have facilitated your client's reunification or would have furthered your client's reunification with the client. Okay, so the responsibility for adequate due process does not end with the court. Juvenile court attorneys contribute to the problem when they attempt to expedite the process. So when you're going into the record, I get that the court is moving you as fast as they possibly can. And maybe even you want to move as fast as you possibly can because you want to get back to your office and start processing and developing your cases for the next day or for the next week. But there's got to be a part of you that slows down, even if you're going to get, crazy looks from your opposing counsel, or if you're going to get pushed back from your bench officer. You gotta slow it down so that you don't miss the objections, that you don't miss the reasons why things are being continued, that you don't inadvertently submit on a recommendation, and that you don't overshoot the most important facts of your case while you're trying to persuade your bench officer to rule in your client's favor. It's incumbent upon the attorney to devote sufficient time and effort to afford their clients proper representation. Efficiency and effectiveness are not mutually exclusive. It is often wise to spend a prudent amount of time at the outset so as to avert future trouble. Okay, so easier said than done, which brings me back to the handout. There's not a lot of time to do everything that we want to do on all of our cases. But at a minimum, the issue should be there in your head so that as you're going through a particular day and you have a 2.5, a juris, a dispo, a TPR, and you're bouncing back and forth from one code section to another in rapid succession, you can spot those issues quickly and it won't throw you. Because that's what throws me. That's what has thrown me over and over and over again. I'm bouncing back and forth from one procedural posture to the other. There's a code section that I know applies to what's going on, but taking that hat off, putting that hat back on, doing it again and again and again, it's hard to keep track. So the handout is kind of something that I wish that I had, and in fact just started doing it for myself. I just wanted some place to go to so that I could just see, where do I need to make these objections? I don't necessarily know what the code section is, but I know enough to know that it's somewhere in the code, and I either need to go find it, ask a supervisor, or come upstairs to the 5th floor and ask somebody over in this section here. Enough to just say, she said something about that. I don't really remember. I need to say something now. So let me go to this portion, surviving your mistakes. Okay, so a couple of things that you can do. You've made the mistake. You've made the mistake. I have maybe had a conversation with you. You've had a conversation with your supervisor. So what do you do? Okay, one thing that you can do. So this first one, raise the objection by questioning the procedure or the order. So this is probably what I could have done when I was representing Dad in NRA EA. I wasn't necessarily, well, there's a backstory, that's a whole nother training. But I wasn't necessarily 100% clear about what the language was in that code section. I knew it was 361.5B. But what I could have done was I could have backed my way into the objection by saying more about why I thought what was done was an error. I could have said something more about the social worker didn't even call the jail. Now, in that, I'm not saying 361B, 361.5B, and I'm certainly not using the exact language that's in the code section, but I'm backing my way into it. I'm giving him some more information to consider. I could have also said something like, there's a relative who could bring EA, who could bring EA to see him and visit. I could have said something like that. That would have been the portion of the order or the objection where I said, I'm objecting to visitation being only after he's released. I could have said something like that. You know, something to back your way into objection. You know it's there. You don't know the language. You don't know the code section, but just talk it out. Just talk it out. Okay, the next thing you can do to survive your mistake, submit a walk-on request. Now, I have been hearing that it's not so easy to do this anymore. That's not so easy. It was easy for me. It was easy for me to do it. But as I understand it, it's not so easy. Okay, taking into consideration that it is not so easy, then if you have to do it right. You submit a walk-on request. Somewhere in your walk-on request, you're going to say what the order was. You're going to say what the error was. You're going to list what order you want, and you're going to say why. Under Welfare and Institutions Code Section 319, the court should have made detention findings. Okay, something like that. Especially if you phrase it the right way, the court should be like, you know, we need to put this on the record, and they'd be willing to interrupt their regular calendar to put it back in, and then you can be heard, and you've survived your mistake. So that's one thing you can do. File a request to change court order. So that's your JB 180, and that's pursuant to Welfare Institutions Code Section 388. Depending on how the order was made, what new evidence you have to present to the court, you could probably survive a mistake by filing a 388. Now, if nothing more, a 388 has to be filed, and it makes it into the record. So even if the court summarily dismisses it or denies it or does some kind of something that wasn't exactly what you wanted, it's in the record. And perhaps if it has to go to appellate review, somebody can do something with it. It's got to be real juicy, point something out. He did something here. There was new evidence here. I'm asking for this. This happened. Some way, somehow, to kind of go back and say, this was an error. I'm trying to correct it. The court didn't want to. I did my best. It's in the record. Okay, this one, if it's heard by a referee or commissioner, can you maybe do a rehearing on it? I don't know. Is there a reason why you couldn't do a rehearing? You didn't win. You messed up. It happens to be in front of a referee or commissioner. File a rehearing. Do it all over again.
How many days?
Oh, Lord.
10.
Huh? 10. I'm not teaching the word code today. I'm sorry. All right, so that's the end. So let me just take the handout. Okay. Have you guys had a chance, or let me just go over some of these. Okay, so there's some of these that we didn't get a chance to talk about because I didn't put it in the presentation. Okay, so on page 2, the appearances. Another common area in the record that sometimes has an effect all the way down the line when we finally get to a TFR or when we're finally getting to a TPR. Okay, has the client requested to be appointed counsel? Are you just being in front of a court? Are you making a special to call the client? Think about what you're doing. A lot of different people have a different way of doing it, so I'm not going to tell you what one way to do it. Again, the purpose of this discussion is to flag the issue. If you want to have a discussion about what to actually do, you go to a supervisor. You come up to the 5th floor, but somehow, some way, the issue needs to be there in your mind so that you don't miss it and step over it. Is the client making his or her first appearance after the court has made dispositional orders? Immediately, you should be thinking about Ainsley motion. Are you making a general appearance? Are you making a special appearance? Has notice been made proper? They're coming in after dispo. Okay, does the client reside outside of the United States? So automatically you're thinking, does this person reside in a country that is part of the Hague Convention? And is there notice? So you got to stop. You got to slow down. Go through the reports. Think it through before he's calling the case. And then you're already on the record making the general. Has your client requested to be appointed counsel for a new case concerning the child's sibling? So you're already in the case. They have a new child, or there's a child that wasn't filed on, subsequently filed on. You're at the detention hearing. The client's not there. Are you picking up this client for this child as well? That's a discussion that you need to have with the client. You need to ask, Your Honor, I need a continuance. Let me have a 1 day. I need to call the client. Something like that. Just be mindful. It may not turn out to be anything that's going to hurt the case. The point is to flag the issue and resolve within yourself, this is nothing. Or, oh, this is something. I need to do something about it. Okay, with evidence. How do I make sure that the information becomes evidence in the record? Well, is it admissible? Ask yourself those questions. Did you proffer the documents for admission into the record? That's what I was talking about earlier, where there was a record where there was a dispositional order that definitely was signed by the judge, definitely was signed by the client, did not make it into the court's legal file. The court was going ahead and just assuming at the 6-month, 12-month, 18-month status review what the orders were. Counsel then raises it. I have a copy, and starts just reading it, but never actually admits it, never marks it. So you gotta do that. Did you present? Yes.
What happens when you want to do a writ and you haven't admitted that evidence?
So many times we are going through the record to determine whether or not we're going to file the writ. I'll see that the petitioner's evidence is always there. Petitioner's 1, 2, 3, 4. Not only does the counsel make sure that there's an exhibit list, but then you hear the court knock them out. Then, somewhere along the line, it switches over to the parent's case in chief, and the parent says that there is, a certificate of completion. He's finished drug treatment. So I don't know why this recommendation is. Do you have the actual certificate of completion? Are you just holding it in your hand and just kind of showing the court? Or are you actually saying, I'd like to mark this as Mother's A. I'd like to now admit it into evidence. I've made photocopies, and it's been passed out to all counsel. When I get a record where there is discussion about a certificate of completion, or not even a discussion, but just a statement, she's finished. She's finished. And I go through the record, and I don't see anything like that, there's nothing that I can do. It's not in the record. It's not evidence. It wasn't something that the court read and considered. And you guys know that phrasing, right? After everything is done, you finish with closing arguments, court read and considered. Court read and considered, everything following court read and considered is the record. And if the court didn't read or consider your document that you're waiving or speaking of in your closing, it's not evidence. It's not evidence. So there's nothing that I can do to point the Court of Appeals' attention to the document because it wasn't officially marked or admitted as evidence. It was just spoken about. So it wasn't read and considered. Okay, same thing with the witness's sworn testimony. A lot of statements about what someone would say or what somebody said. It's not in a report. It's definitely not somebody who was sworn in, questioned, cross-examined, and it came out. It was just something that, you understood because you talked about it outside, and you understand it. So when you're doing your closing argument, you're saying, oh, well, the grandma will let them live there. It's not enough. It's got to be in the record, and the way to get that kind of statement in is to actually put the witness on the stand. Okay, and then here's the other one. I don't see a lot of this, recordings, photographs, and social media posts. So that's real fun. I don't know how many times we get a chance to do all of that. But there's, certain rules to actually authenticate it, make sure that it gets in the record. It takes some time. I'm not going to say that it's the easiest thing to get in because you have to do one more step in your research and making sure that it gets in the record properly. But I mean, how many times do we say, well, there's a text message here. It's on the client's phone. Hold on one second. And you're trying to retrieve it. And here, listen. It's not going to work. You got to find a way to get all of this new evidence, the most frequently, reported on evidence where you get the social media posts and the text messages and all that kind of stuff. You got to find a way to get that in the record properly. Now, assuming that the court kind of lets you slide on authenticating all that evidence, good, it's in. Nobody objects to it, great, it's in. But I see certain attorneys struggling because they know they have some real good evidence, but not sure how to move it into evidence and make it part of the record. So then I'm reading it, and it's in the closing. Great, it's in the closing. I can't do much with it. Okay, last but not least,
what is your view on us objecting to social media or photographs in the department's reports as they submit as attachments?
I object whenever you think you need to object. Whether or not you are successful in that objection is for the judge. That's for the judge. Your role as the trial attorney is to raise those issues. That's what you're doing. And that's the whole thing about, feeling like IAC is on you. You don't have to feel like IAC is on you. You're an attorney. Your job is to put on your suit, walk into court, and raise objections, make arguments, admit evidence. That's what you're supposed to do anyway. So if you're doing that, you're not concerned, or you shouldn't be motivated by IAC and whether or not something down the line is going to come and bring up an issue or mistake that you're not going to make anymore. So object. Object. Be wrong in your objection. Be overruled. The point is that you made the objection. Okay, requested orders. Okay, I see this a lot. I'm just raising the issue to see whether or not this comes to mind. I see a lot of, Your Honor, we're asking the court to return the child to the parent. And in the alternative, if the court is not so inclined, we're asking the court to find no reasonable services. So I understand the bifurcated argument where you want the court to do this, and then if not this, then do this. I would say that you ask for the top thing. Just ask for that. When you kind of ask for the other thing, you give them an out. And I know sometimes, well, I want to control the out. If they're going to not give me this, I want them to give me this. Just go for the top one. Argue the heck out of the one that you want. The order that you want is the one you're going to argue, and you're going to persuasively order that one. And so while I'm not discouraging in the alternative, the court is so inclined, just think about it. And then particularly when you're doing the reasonable services in the alternative. There is argument that if your client is asking for the kid, then your client has rehabilitated and services were so good that the kid should be returned home. And the argument is that why would there be a reasonable services issue if your client is now rehabilitated and did everything that they were supposed to do? So I've seen it kind of questioned in the opinions, but I just bring that to your attention so that you guys can think about it. If services were not reasonable, then you're asking for the finding and you're asking for continued services, assuming that you have the time. But if your client is rehabilitated and it's time for the kid to come home, I don't know why you're asking for the reasonable services. You're done reunifying. Just something to kind of put out there. Okay, any questions? We're at 1:14. Okay, no questions. Thank you, guys. Thank you.